like to call this meeting of the Town Council to order. Chairman, would you call the Planning Board to order?
Yes, I would like to call the planning board to order, please. And I will turn it back over to you.
Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please bow your heads for a moment of silence. Thank you. Katie, would you introduce our topic this evening?
Good evening, Mayor, Council, and Planning Board members. The town's updated strategic plan was adopted at the June 23rd Town Council meeting. Holding an annual joint meeting is one of the goals included in our strategic plan. I know that you have all received lots of questions about short-term rentals from members of our community. This meeting provides an opportunity for Tom Terrell, the town's land use attorney, to address some of the concerns that have been raised. Thank you all for attending tonight's meeting to discuss short-term rentals.
Thank you. Anna, would you introduce the regulations?
Good evening, Mayor, Council, Planning Board. The interest in use of short-term rentals has, so things like Airbnb, VRBO, or Vrbo, has increased in popularity over the past several years. Many local governments have sought options on how to best address the increased use of these rentals, both legally and practically, through local regulations. In fact, the town first reviewed information and options on how to regulate short-term rentals in late 2017, early 2018, in which the Planning Board directed staff to wait on guidance and more information from other local governments and the School of Government before any new regulations were recommended to Council. Fast forward to 2022, many local governments have adopted ordinances restricting locations, quantity, requiring registration for short-term rentals. The School of Government even put out a guidebook, Regulation and Taxation of Short-Term Rentals. And now, with what appeared to be clear guidance from the School of Government and precedent sent by local other municipalities, a planning board member asked earlier this year if staff could once again review options for policy. However, that was in March, and in April this year, North Carolina Court of Appeals ruled in Schroeder v. City of Wilmington that state law prohibits a registration requirement for short-term rentals, bringing staff and planning board and council, I'm sure, back to the question of, well, what can we do? Fortunately, we have legal assistance to ask these hard questions about new case law. So I'd like to invite the town's land use attorney, Tom Terrell, to provide information about the current status of laws related to short-term rentals, and to give council and planning board members the opportunity to ask him, and of course Beth as well, questions you may have about short-term rentals. Here's Tom.
Thank you.
Thank you, Anna. Mayor Montgomery, I would like to begin by correcting an omission from the council meeting last week. At the very end of the meeting, Councilmember Strong asked me if I had anything else to say, and I answered with the one word, no. But it was actually the perfect opportunity in the context of describing a developer that was not rising to the occasion to have shown the contrast of the town of Jamestown staff. And I failed to stand up and to have addressed that specifically, but I would just like to say that I have, over 37 years, worked with, it's a guess number, but it's around 400 counties, towns, cities in 4 states. And your staff is collaborative, they're smart, they're kind, they're easy to work with, their heart is in the right place. It has been a true honor to work with them. I wish I had said that when I was asked a question. So I thank you for the chance to correct.
And we
the omission.
appreciate that. The staff
I was
appreciates
not trying to
also.
put you on the spot.
No, that's okay, but typically I think a little bit faster on my feet, but it was late at night. I think that the issue that you're trying to ask and maybe answer, if it's possible, is what can you do, what can't you do with what we now call short-term rentals. It's an issue that is broad, at the same time, it's very narrow. But I want to give you the bigger history. I want to talk about what states do and what cities can and can't do, so you can understand where your powers come from. So there will be a little bit of a civic lesson in here. I hope it doesn't take you back into boring ninth grade civics or something. I'm glad to have Judge Walker here because I think he can verify this. When he and Beth and I were all in law school, all of us studied cases about property and property rights and how you own something in fee and what those rights were. But many of the cases that we studied in law school property class dealt with leasing and rental, or if some of them did, and they go back to England, they go back to the early parts of this country. But the basic rule is that being able to lease your property is a right that has existed at common law. We've always had that. Whether you want to admit it or not, the person who has the largest home in Jamestown, if they chose to, could convert it to a rental house. But we're talking, though, in that instance, as a long-term rental, not short-term rental. So there are two different kinds of rental. Now, as I say here, you can contract it away, and this is very common, to have restrictive covenants and things like that. Now, short-term rentals are very common. I have rented my house, our house, during furniture market going back to the 1980s. We don't do it anymore, but I think everybody who's here who lives in this area understands that renting during market is a time-honored tradition. And these are people, when we've rented to them, this is how they make their living. It's not a party boat for them. They are there to make sales, buy, or whatever. And at the same time, most of us, if we did a show of hands, have been down to the coast and rented a home right on the water or not too far away. Owned by a family, managed by a company, and we want to go down for a week or two. Some of you may have beach houses that you rent out. So this is another context in which short-term rentals have been very much a part of our economy, who we are, and how we deal with property. But now the world is changing, and it's changing very, very fast. Now, I call this disruptions by the digital economy, and I give some examples of how, where things ain't what they used to be. But where, for relevance of this conversation, Airbnb and VRBO, and there are others, those are the two main ones, are taking over where the hotel industry used to be, and they are taking a huge slice of that. Airbnb last year had almost $5 billion of profit. It is not a small company, it's publicly traded, and I, just like most of you, probably wish that we had bought substantial amounts of Airbnb stock the moment it went public. But the question, though, comes, can they be regulated? Everybody has stories about party houses. This was, in fact, when Asheville started to try to regulate Airbnbs. In fact, they were the first one really to get into the marketplace, and so we tend to want to generalize and call all of them Airbnbs, but they're not. But there were some very prominent anecdotal stories in established neighborhoods in Asheville where there have been very disruptive parties, and there was a groundswell of effort to regulate, and Asheville did start to regulate. At that point, the General Assembly got involved, and I want to, before we, before we go too deep into the General Assembly's involvement, I want to tell you who they are. The state of North Carolina is a sovereign. And when I say the General Assembly is the body that passes the laws in North Carolina by which cities have to operate. In case you needed a reminder from civics class in the 9th or whatever grade, a sovereign is somebody that's free from external control. Nobody controls them. An autonomous state, a supreme power. So that's the general idea. And the state of North Carolina is sovereign in everything it does, except where the federal government is sovereign over the states. And we don't need to go deep into that, except to say that except where there's federal sovereignty, states may step in and regulate everything from land to commerce to employment, building inspections, you name it. When it comes to local governments, and I'm telling you some things that I think most of you know, counties are subdivisions of the state. They pay for schools, they pay for jails, they do health care, social services, things like that. But a city is different. A city exists by corporate charter. And it's in that corporate charter that the state says, we allow you to come into existence. And you have the powers that we say you have. And there are two ways that the state can say you have powers. One of them is in the charter. That charter can grant express powers, or it can limit the powers that you have. The second way the state can grant a municipal corporation power is by statute. Now, it is important to, well, let me go back, leave it there. It's important to note that there is now a whole raft of cases, most of which have come out of the zoning and land use area, that say if a city doesn't expressly have the powers to do X, city can't do X. There was a big case that came out of the Supreme Court, the state Supreme Court in 2016, over whether or not a municipality, in this case it was the town of Carthage, could charge utility customers a fee for the future expansion of its utility system. And the state Supreme Court said, you can't do that because the words are not there in the statute. Counties can because it's in the county version, but it's not in the city's version. And it was an express reading of the statute. And so if it's in the statute and the words are clear, courts don't even construe it. Now, I'm going to look at this. General Statute 160A is the statute that used to be where all of the land use and zoning and building inspection statutes were located for cities. Counties were in Chapter 153A, but there was a statute that was enacted in 2011 that restricted the right to regulate short-term rentals. And this was a time when Airbnb was just starting to get off the ground, and the General Assembly stepped in and said, we're going to limit this. But what they did, and it's important to note right here, is that they says you cannot require an owner of property to come to you for it to be issued a permit or to be granted permission. So that was the limitation of it. And they did have an exception. If it was a hot spot for criminality, then they could step in. This was basically an acknowledgement that there are what are called nuisance abatement statutes out there. But in this case, they says you can't make an owner of land. It was a property rights statute. You can't make them come to you for permission. Now, that was 2011. In 2017, the General Assembly went further and said you cannot make a property owner register their property. And that was the added language that came in 2017. Now, there was something else happening at this time. Let me finish my slides here. You can't require registration. You can't require them to get permits or grant permission. So your hands are tied to a great extent. And basically, it takes us back to the common law rights. Now, along comes a case, I have a copy of it here, called Schroeder versus Wilmington. And in the Wilmington case, let me go to the first one. This is what was happening here. The Schroeders owned a short-term rental. They had a condo. And as I put up here, it was in the Lionsgate community. I don't know what Lionsgate community is, but I'm gathering it was a community that had some degree of pride, some cohesion, and all of that. And the Schroeders never had an issue. But there were issues in Wilmington. Wilmington is a tourist destination. Wilmington is a place very, very popular for Airbnbs and VRBOs. So they passed an ordinance that says we're going to limit short-term rentals. And we're going to make you register, and you have until the end of the year before your grandfather status runs out. You have to enter into a lottery to be chosen to have the opportunity to have a rental, and you cannot have two within 400 feet. So there's a distance separation. And now, you can read this between the lines. Schroeders really didn't care about this as long as they got chosen in the lottery, but they did not get chosen in the lottery, but a neighbor who lived down the street did, and that made them mad. So they went to court to challenge the statute. And for the judge, I'll say, I don't understand the procedural history because it went to the Board of Adjustment first, and then they filed a declaratory judgment, and you can't do that out of the Board of Adjustment, but this is apparently what they did. And in the meantime, the statutes were recodified by new Chapter 160D. Now, let me go back. Anna, how do I go? Scroll back? Wait a minute. I'm scrolling. Okay, wait a minute. Okay. What did the court say? I want to talk about the recodification of statutes because that's where Wilmington was coming from. But this is what the court said, and this is the sovereignty issue. It's the opening paragraph. It was written by Judge Lucy Inman, she's brilliant. Her opinions are always very good. She says the North Carolina Constitution establishes the state as sovereign, and local governments may exercise only those powers that our General Assembly deems advisable. In other words, it's entirely within the General Assembly's discretion. When a question arises regarding the scope of a local government's authority, it is the judiciary's duty to interpret the enabling law and apply it in accordance with the General Assembly's intent. So what is going to happen here is the court is going to be looking at the statute on short-term rentals, and it's going to apply it to the Wilmington Ordinance and ask the question, did Wilmington have the statutory authority to enact this ordinance? Now, on its face, they did not. Because they were doing the two things that the statute says you couldn't do. And I don't know how they even thought they could get away with that, but they were trying to do it. But they had a brilliant legal argument when they got to court, because what was happening during this time was a recodification of the statutes into what we now call 160D. I'm really enjoying standing here to tell you about this because 160D started with me recommending that we do this. I was chairing the committee for the Bar Association that was rewriting the Board of Adjustment legislation back in 2013, and I turned to the drafting committee at one point. I says, we should do this for the entire kit and caboodle. And everybody thought I was crazy. And then a couple of months later, Dave Owens, the professor at the School of Government who does land use, called me up and he says, were you serious about this? I said, yes, I was very serious. So for the first 6 months, Chapter 160D was Dave Owens and me sitting at the School of Government going over the framework. But I'll have to tell you, he was the mastermind who was moving all of these pieces around for what we ultimately now have. But what was it? 160D was an update. The last time we had modernized our zoning laws was in 1923. And we had county laws, we had city laws for land use and zoning, and there was no reason to have parallel zoning except for, we have some things on farms in the county statute. So what we did, we merged them. We brought the language up to date so that it made sense. All of these ordinance statutes that were written at 11 o'clock the night before the committee met at the General Assembly, by somebody just out of college, that doesn't make much sense. We tweaked the language so it was clear, but we were telling every stakeholder throughout the process, and it took 6 years to get this through the General Assembly, but we were telling everybody, this is a recodification and it's a modernization. We are not changing the law. The law stays the same unless there is sufficient legal precedent by courts to update it, and we did some of that, or there's a consensus change and nobody's complaining about it. Like, for example, we made all of the processes for notification for a variance and a rezoning and other things, we made those uniform. Nobody was complaining about that. And so we created a uniformity there. But that was the hook that the city of Wilmington looked to. I've already mentioned that. If you look at the language, first of all, we in 160A, which is where the original statute came from about short-term rentals, we took out every place where it said city and we put local government, because that means it applies to a city and a county. And I don't know where this language came from, but we said in no event, this is the 168-424 updated. In no event may a local government do any of the following. And then we go on to talk about the permission part and the registration part. But we said under Article 11 or Article 12 of this chapter. So the question is, of course, there was a drafting committee that was doing this, but it was adopted unanimously by the General Assembly. The question really is, what did the General Assembly mean when they took this language and adopted it? Were they creating a limitation to Articles 11 and 12, which are the building inspection articles? And that was Wilmington's argument. Now, the outside counsel for the city of Wilmington called me 2 or 3 times during this time to bounce ideas off of me to see if I could answer some questions for him as he was honing his arguments. And the short version of what I said to him each time was, Bob, I don't think we thought about this. I think it's just something that got written in and nobody was thinking that it might have a meaning, and I really can't help you. I wish I could. But his argument was it meant that you could regulate it under the zoning statutes. I actually thought that was a brilliant move. I would not have thought of that, I don't think. But the Court of Appeals said, as I wrote, nice try. And the Court of Appeals looked at the intent language in Chapter 160D, which was not to change the law, and says because that was the intent, we're still back at you can't require somebody to come for permission, and you cannot make them register. Now, so the question then you might ask, okay, but is there something that we can do when somebody has let's call it a party house, has a short-term rental, and they constantly have people coming and going and loud music and carrying on and carousing? Yes, you probably can have a noise ordinance. In fact, you can have a noise ordinance that addresses that. If they do anything that is expressly a violation of a criminal statute or any civil ordinance, you can. But, as I said, more handcuffs. There's an effort right now to decriminalize a lot of things that probably should never have been criminalized in the first place. It's a national movement, and the zoning ordinances across the state very commonly have criminal sanctions for what should be something that's civil. And we're now saying you can't do that. So you cannot use a zoning ordinance as a way to create a penalty, a criminal penalty for somebody who is engaging in loud partying. Now, is there anything else you can do? This is a big question. There's a lot of debate. There are a lot of questions now about what powers municipalities would have to regulate short-term rentals. One of them here is untested. Nobody has challenged this, to my knowledge. If it's being tried somewhere, I don't know. All I know is it's been an article that I've read about this. And it talks about there being two classes of dwellings. One of those classes is the dwelling unit, which is the single-family home, for example, where you have everything in that dwelling unit that you would have to have for it to be approved and granted a certificate of occupancy. That includes, for example, a kitchen being the main thing. But then you also have a transient use of property like a hotel. And you would not require a hotel to have a kitchen, but they would have to have a bed and a bathroom, which is basically the essentials for a transient place. And so the question does arise as to whether or not you could create I'll call it a hoteling ordinance that says you cannot, you could define short-term rentals as a type of hotel use and then regulate it that way by saying you have to get rezoned, or you would have to get a special use permit or something to that effect. If you did that, probably you would have to do the same thing for furniture market rentals, so that would be, you'd have to be careful that you're not knocking, in fact, I think you would knock people out from furniture market rentals. But I did want you to know that that is one of the things that you probably could do. So this is where the General Assembly is right now. It's where our courts are. I have not seen that Wilmington has tried to appeal this to the state Supreme Court. They might have. It would not surprise me if there were not sort of a desperation attempt. But it was a unanimous opinion of a 3-judge panel, and in order to go up to the Supreme Court in that circumstance, you have to have what's called a writ of certiorari, which is permission of the court for the Supreme Court to hear it. If it was a divided panel, you have an automatic appeal to the state Supreme Court. In this circumstance, you have to show them that it meets one of the exceptions in the appellate rules for going higher up and make a very compelling case. The state Supreme Court is very stingy about those writs. They don't issue them very much. It's about 5% of the requests to be heard on appeal are granted. And in this case, I would be shocked even if they asked if the Supreme Court would grant cert. There's nothing about the case that would meet any of those exceptions. I'm glad to try to answer questions that you have, but I will tell you that that most of what I will say were answered in the title slide, is that for the most part, at this time, you're looking at can'ts in legislation, not cans.
Quick question then, guess I get the ball started. And let's say in extreme circumstances where obviously we can't do the prior regulations and those sort of things, but work on it as it becomes a problem. What's your experience in something when it comes, or in issues of homes or businesses as far as using the nuisance abatement?
Usually that's what?
The nuisance abatement?
I've only done one nuisance abatement in my life. The city of High Point was my client. It was for the Kivett Drive Grocery out on Kivett Drive. It was not very successful and on a lot of levels, but that statute and any local ordinance would be available to you. You would have to show that it is a hotspot of criminality, and if that were the case, there's an exception that is still in the 2011 rule. But that should be available to you for that.
Well, of course, I was hoping we would get some answers to what we could do, not just what we can't do. Of course, the town does have a noise ordinance, and we need to make people aware of that or have it on the website so that if it is a party house or there's parties going on late, what they're supposed to do and that kind of thing. But I was wondering, I think I had read several articles. I read several articles about these investment companies buying up homes and how it's pushing people out of the housing market.
Yes.
It's making people be renters and not have a choice to be a homeowner, which is another facet of this, really. But we talked about or read about where, especially with new developments that have homeowners associations or developments in your restricted covenants, if there's some way to have those in the bylaws or the restrictive covenants, a percentage of dwellings can be rental, or so many out of that could be. If that was written into the restrictive covenants or the bylaws.
I step onto thin ice when I start trying to tell you the laws of what you can and cannot do with restrictive covenants. I would defer to what Beth would say on that. I can tell you that you're talking, though, in that circumstance, really, it's a long-term rental, not a short-term rental.
In my opinion, Tom, I enjoyed the presentation. It was good. In my opinion, the best way to regulate this is for neighborhoods to set up their own homeowners associations if they don't have them, or change their restrictive covenants, if they do, to prohibit whatever it is, short-term rentals, percentage of houses that can be rented. I do think that's probably your best bet at this point. Now, I'm not aware of any test cases. And as far as I know, Tom, do you know if that's been, I don't think that's been litigated.
It is not to my knowledge.
And so I don't know whether that would hold up or not, because as Tom pointed out, the right to rent your property and a prohibition against it, I think you're looking at what they would call a restraint on alienation, which is sort of how arises from the common law, as Tom explained. So it's a kind of a bedrock right that it's your property, and if you want to rent it, you can do that. However, I am routinely seeing in homeowners association documents now prohibitions against renting. And they have some rules about it, so, requiring you to, maybe the lease has to be approved by the board, no short-term rentals, it can only be for a year or more, different restrictions. But in my opinion, that's probably going to be your best and safest bet. If a neighborhood is interested in this kind of regulation, Tom may have a different opinion, but I'm just not sure that I see the government stepping in and doing anything about that.
No, I'm fully with you as to government's hands being tied. We talked about, a minute ago, about sovereignty and about the express limitations that were in the statute 168-424, which became 160D-1207, if you wanted to see it. But if you tried anything else, you still must look at Chapter 160D to see where is our express power coming from. Because whatever you try, you have to match it with a power. And anymore, there are, I guess you call them zoning plaintiff ambulance chasers, who are out looking for governments who are violating their rights given to them by the General Assembly. It was a cottage industry. There were 2 or 3 law firms that were handling all of those utility cases, and they made a ton of money on it because the municipalities and counties were required to pay the attorney fees under a statute. There's only one county that I know that beat it, and that was my client, Harnett County, and we had a Supreme Court case from 1990 or 91 that created a precedent for what they did specifically. But it's, there could be a cottage industry that comes up on this after this case if other municipalities try to get creative. You might have ideas. You just need to look very carefully and think it through before you try something.
Then the only other thing I was going to ask about, when you were talking about the furniture market, people that rent to the furniture market, and if you tried to, if you could find a legal way maybe to regulate it, that it could hamper that or hurt that. But I thought the state has some special tax laws for people who rented their houses to the furniture market. It's like, what, twice a year, 10 days a year?
Well,
so couldn't you somehow have that as the exception?
Thank you.
Yes, you've got, have that as the exception.
Yes. Yes, that's exactly right. But a tax law does not interfere with, a zoning law exists independently of any tax laws that might be out there, because any state or federal tax law cannot grant you zoning permissions. But no, it's a very well-known exception, although I will say, when I start talking about tax law, I'm on extreme thin ice. I defer to the mayor.
So I'd like to springboard off of something that Martha asked. When you cited the Wilmington case, obviously it was dealing with proximity to each other and how many rental units you can have, and you've got a little bit of there's a small contingent out there of, I'm just going to call it predatory buyers that are looking to snatch up whatever properties they can get their hands on. So what happens if you have a situation in a town this size, for example, that you have a cluster of homes in very close proximity purchased by one person? Obviously, we talk about property rights and, freedom to go in that direction, but are there any caveats that came from the Wilmington case that allow us any interpretive flexibility?
None that come to my mind, but
I was afraid you were going to say that.
But you're skirting around an interesting issue here. I don't know how, I don't want to sound like Bill Clinton and what does is mean, but I don't know what short means. And I don't know if it's defined by statute or ordinance, but that, there could be some flex there. When somebody comes in, I like your term, predatory buyers, but they're doing this for long term. They want long-term leases. And this is something that started back after the Great Recession in 08, 09. It has continued to pick up steam. It has really picked up steam during COVID when you have more and more money being poured into these outfits. Some are just investment firms, some are REITs, some they have different forms. But ultimately, what they're doing is that they're buying properties. Sometimes they're coming in, to use the example of D.R. Horton. D.R. Horton, more often than not, is a builder, not a developer, and they acquire a development and then do the building. Sometimes these developers are building not for a build to sell like D.R. Horton, but they are developing a subdivision at the outset to be a build to rent. And that's what you're going to start seeing more of. It's kind of like an apartment complex, but in the form of single-family homes. And that's the next trend. Change is the only constant, right? And we're just going to have to see how that comes about.
Tom, trying to get my arms around all this. I've got an article from the School of Government, short-term rentals after Schroeder, and I want to read a paragraph real quick and then see if that gives us some room. But it says, the court identified the following ordinance provisions as preserved, not preempted: restricting whole house lodging to certain zoning districts, parking requirements, one off-street space per bedroom, prohibition on variances, operating limits and requirements, no large events, maintain insurance, manage trash, no food prep in bedrooms, posting safety information and other use and safety requirements not preempted.
I think all of those fail and fall because they are other forms of getting permission.
Tom, could I ask a question about whether or not you think, or how strong you think regulation could be through zoning? And I'm not talking long-term rentals because I think that's an issue. I don't think it would work for that. But if what you're trying to regulate is not having someone buy a home and operate it as an Airbnb, then would it be feasible to enforce your zoning ordinance with that as a hotel, as a commercial use?
That's what I was raising in that last slide. It would be basically creating zoning categories and saying, doing this, I'm going to face this way, but.
Sure.
It's saying something that is the express purpose of creating a short-term rental as opposed to long-term rental would be a business rather than a residence. I have hesitations about whether even that would work because when I own a rental home for long-term, it's a business. And I don't know, under the 14th Amendment, when you start distinguishing between types of people or categories, you have to have a compelling interest, the government does, in order to make those distinctions. And I don't see it. I really don't. And I think that any efforts would be unsuccessful.
The deeds of the home say in a residential area that it will be the primary use of a single family in most cases. Mine does, and I know several others that do. And is that not going to preempt these businesses being in these single-family homes in those areas?
Let me begin by saying I don't know. I grew up in a house in High Point that was deed restricted by race. And that was overturned by the Supreme Court. but it's part of our collective history. Then we have other U.S. Supreme Court cases that talk about what a family is, and and you can't define a family anymore. This is 40 years old as man, woman, children.
Agreed.
So I don't know what your deed expressly says. I don't think that in itself would prevent or would give somebody an opportunity to sue you to enjoin any renting.
Well, what I'm saying is that if it isn't owned by an individual person when they bought it, if it's owned by a company rather than a resident, somebody who's going to live there, and a resident would be someone who's going to stay long-term rather than transient, so wouldn't that be something that we could hang our hat on somehow?
I don't think so. There are, where do you live?
Cedarwood.
In Cedarwood. I have not looked at the deeds in Cedarwood, but I have looked at the deeds in a lot of neighborhoods. I'm willing to bet that there are a lot of non-individual owners in Cedarwood, if only as trust, you know.
Oh, there are trusts.
Yeah, which is there are different ways of ownership. I think that the answer is probably out there somewhere of something that you could do. I think I've read the School of Government article and my eyebrows went up because you either have to violate the registration at some point or those are surrogate actions for permission. And it's singling out a certain activity. I don't think it would pass court muster. I should have probably gone deeper into that, but I just don't think it would work.
How do we define a residential neighborhood then?
It's an interesting question. It's not defined by statute, but it's not, residential neighborhood is not a zoning category either. What you do have, though, are zoning districts that are primarily for single-family residences. But even in the Jamestown UDO, you will see that in that zoning district, schools are allowed, churches are allowed, maybe daycares. I'm not sure, but there are a lot of uses other than single-family homes allowed in your residential districts.
Tom, going to Beth's point, and it doesn't really help us, I'm just curious. So for instance, could a bed and breakfast now under this case say, you know what, we're not a bed and breakfast, we're just an Airbnb, and we don't want to follow all those regulations anymore, and we just happen to, you know, make food for people when they're hungry. Can they do that? I mean, because I had the same kind of thought that Beth had, like, they're operating a commercial property in a residential zoning, and an Airbnb, not an Airbnb, a B&B is not, they have to follow really strict guidelines, and so how does that, John?
That's an interesting question. I haven't thought about that. That's a novel question. The only answer that I would pose without thinking too deeply is that courts tend to do a pretty good job of looking at the substance of something rather than the nomenclature. You know, I could call myself an elephant, but a court would look through that.
Right. But so in that case, and I'm not an attorney, so I'm just spitballing here. I guess how would they make the distinction that an Airbnb that was bought by someone to operate only as an Airbnb, and this was bought by someone to operate as a bed and breakfast, how would those be how would there be any distinction from a court of
Well,
that?
first of all,
difference?
a bed and breakfast in its more classic use has the owner or an operator on site at all times, and they are serving meals and have multiple rooms where people can stay. So it really does fall into a hotel-motel classification. Now, in our tables of permitted uses that we see in different zoning ordinances, typically you have a bed and breakfast listed out on its own, but if you follow it across, you will see that it's allowed in more zoning districts than a hotel or motel, precisely so that you could have an historic home in an historic area used as a bed and breakfast.
Okay. I was just curious.
Yeah.
Could there be a delineation between, among the types of short-term rentals? For example, home occupation, renting out for 2 weeks to furniture market or a golf tournament or something, but the owner lives there and rents out. And then another one would be primary residence, where they live there most of the year and go to the beach for 2 weeks for someone to come in and rent the home, versus whole house short-term rental, where you have in a neighborhood with kids and babies and parents and all kinds of neighbors, and you end up with a strangerhood instead of a neighborhood.
Right.
When you have this turning over every weekend. Can there be that kind of a distinction among the term short-term rental?
I'm going to say no, but only because when the statute says permission, permits or permission, permits mean you have to get a permit, or any type of permission, it means essentially, if you look at it, if you flip it over, it means the government can't regulate. You don't have to go to the government for permission. The government can't take actions to prevent you, to grant you or deny you that permission. So that is the more pertinent of the two categories. It's not registration. I frankly don't think registration is a problem. We register everything. We register our cars. You know, that doesn't prevent anybody from having them or using them according to all the laws governing automobiles. It is the first phrase that was in the 2011 statute, which says, you know, no government can require somebody to come to them to be issued a permit or for permission. And that's where the real action is going to be.
So this hotel that you're talking about, a hotel ordinance, that seems to be a little bit of an opening for us to look at, because people can figure out how to do that if they're going to rent to 2 weeks a year or whatever. And another issue, another thing that I heard third hand, it's not first hand, is that one state has a 30-day minimum for short-term rental. And so
Minimum or maximum?
I think that's California, my third-hand source, so I don't have original source.
Well, I will say this. In the absence of a statutory definition of short-term rental, of express number of days, you should be able to fill in that gap as to what a short-term rental is. It should be a definable term.
Is this something we need to contact our legislators to make that definition, or is it something we can do in zoning? I don't think
I
zoning.
would not go to legislators for that. That's something that you might turn to Anna and Matthew to explore a little bit more deeply and see what they can come up with.
To have a definition of,
To see if, to start looking into and exploring the issue of redefining short-term rentals as a hotel. Is that we don't care that you have them, but you do have to get a special use permit. Now, frankly, I will tell you, this probably going to fall because it's yet another type of permission. And it's the permission that you can't use to deny short-term rental.
if a short-term rental were defined, though, even if it were defined as 30 days or 45 days, you know, that, I don't know if we could do that, but that would eliminate some of this turnover stuff, but yet have openings for things that our culture here is used to. You know, renting out to furniture market and other things.
Which, by the way, creates a real issue. You'd have to really define your way into and out of that conundrum, because we all want to protect furniture market rentals. It's twice a year. It's not a continual thing. And it's part of our economic custom here. And they don't, at least in my experience, they're not here to party.
So earlier, it came up about setting up more formal HOAs, homeowner associations, and restrictive covenants relative to that. But I guess my question becomes, to what degree of efficacy is there, because you have the opportunity to take that to court as well? I mean, I'm trying to figure out where, is it, if a neighborhood wanted to set up something that was more, I would just say more defensive, not trying to tell people what they can do with their property, but it seems like even if you put all that in documented form, people buy the house, they see the covenants, HOA, that's still something that could be contested. So is there a middle ground there?
I can't tell you how many times I've told clients you don't want to be a test case. And you don't want to do business through litigation.
Right.
I mean, it's something of a mantra. I don't know how you would take an existing neighborhood, Cedarwood, for example, and go back and retroactively apply restrictive covenants on people who don't want to have those covenants
Right.
applied to them. In fact, I don't think you can. They bought their house under a set of rules, and you can't, that exist by deed and otherwise. And now, for a new subdivision, you could require something like that.
Yeah, it just seemed like you were digging a hole, not you personally, it sounds like figuratively, you'd be digging a hole trying to go down that path. I was just
Yeah.
thinking out loud. Thank you.
Would that be neighborhood-driven, or would that have to be driven by the town?
It would have to be neighborhood-driven, because what.
So you could have one neighborhood with one set of regulations, and another new neighborhood have a different set.
That's right.
Realistically.
It's all private-driven.
Okay.
But realistically, that already exists.
We do that.
Yes, it
In different
can.
HOAs, you go into some, you can't sneeze without saying excuse me to everybody. I would just like to mention that a lot of people's concerns is you allow parties, speeding cars, drug activity, drunk folks, suspicious activity, any number of things that are currently is criminal conduct, and that the sheriff's office is always available, as long as they're not on another call, to be called to do something about that issue. So it's not all doom and gloom, but it's going to be, if you have problems, then call the sheriff's office, have them come out and respond. If there's something that can be done, they will do it. They're not doing it on part of the town, they're doing it because there is a state law that already exists, or a county ordinance that already exists that they can enforce. And
That's right. When I said on one of my previous slides, unless something is already criminalized under Chapter 14, as you know, but I will tell others, Chapter 14 is the criminal statutes, that everything from how fast you can drive to drunken disorderly conduct, all of that is pretty much in Chapter 14 of the general statutes. But if somebody were engaging in disorderly conduct, however that's defined, at a location, at a house being rented, yeah, that is enforceable through that statute.
now, there are some restrictions. They're going to have to be out in the street, or, they're going to have to call some things. But at the very least, you can get law enforcement on the scene, and if there is something to be done, they'll do it.
I would hope that as a practical matter, if a homeowner knew that their home was being rented for such problems, that they were having to deal with that they would be a little bit more careful and establish some of their own rules.
But when they're LLCs,
Or
Some
you
of
have
them
your
are, yeah.
owners are out of state.
Yeah.
I mean, they've never seen the property, they put a step foot on it, so,
Yeah,
yeah, and absentee landlords.
I know.
yeah.
So Tom, if people are dissatisfied with this, I mean, is there any benefit for people who don't like what we've had to say today? to contact their legislators and say, we don't like these laws and we think these laws should be changed?
Yes, but here's what I would suggest. I read the Schroeder case in an expansive way, because Wilmington was asking for the statute to be read restrictively and very specifically to building inspections and not expansively to zoning. And the court said, no, we read this expansively. So I'm taking that and saying, I don't think there's much room left for a government to step in. But there is probably some political will among a lot of legislators to revise the original statutes. In this case, it would be 160D-1207. That would be the one that would allow that. The League of Municipalities is probably already active in this in some way, but the North Carolina home builders are a stronger lobby at this point than the League. And, I think, and the North Carolina Realtor, I don't know if the Realtors Association would be involved or not, but the real estate development lobby collectively is very strong in Raleigh.
You mentioned real estate agent. I did hear, this is secondhand too, that real estate agents are advising someone who's selling a home they have to let them know if there isn't a short-term rental near there, and it reduces the home value of someone selling. That is what is being said in Greensboro.
I've never heard that. I think that is a little bit of a stretch. I'm not saying it's not being said, and I can see how somebody might raise that question, but I will answer it two ways. One, there is a duty that realtors have, brokers have,
That's what this
to
was.
inform a buyer of things that could be what is called an external obsolescence, or something that would have a direct material impact on the property. If they know it, they have to disclose it. This is not a buyer beware state anymore. The other thing I would say is, typically people think things would have an impact on the market value of something, but I don't know if there are any appraisers in the room, but when you do an appraisal by the uniform standards of professional appraisal practice, and follow those transmission lines, cell towers, rock quarries, there are a lot of things that you would think would have an impact don't. And I would think in that vein, a home that is rented as an Airbnb probably would not. But I've never seen a market impact study on that issue.
It was brought up in Greensboro, and I read it
Yeah.
in print, and I think I sent some copies to a few
Yeah.
people. Because if you have a family who's got a bunch of children, they ride bikes and all of this, there may be some concern about a turnover across the street, not knowing who they are, not knowing your neighbor. Those are the soft issues, but they're important issues for someone buying a home.
Yeah.
What restrictions are there on a homeowner from having any business in their home?
For having what?
Is there any business in their home? Is there a restriction?
Now,
Now, you
Now,
have home
you-
occupation.
yeah, you can, by zoning, restrict home occupation. And there are tax things you can do. You can have, where you can deduct part of your home if you have a business in it. But I don't know what your UDO says, where those types of restrictions typically come to the fore in a zoning ordinance is when that type of business involves customers coming to the home.
Well, in these short-term rentals, there are people coming to the home.
Yeah.
Any number unknown on any day. So what would be the difference of,
I don't know if that question has been asked yet. But what I think better articulated or worded is what you're asking is, could you define or redefine a short-term rental as a home occupation so that it would have to be located in a certain zoning district.
That's exactly where I was going.
Yes, and you may have put your finger on something right there. I don't know how it would go to define short-term rental as home occupation, because we now have a lot of history of what a short-term rental is, and we have a lot of cases out there and a lot of norms as to what a home occupation, but to marry them, I don't know, maybe you could.
Continual short-term rentals would be one definition that could be used, which is what we are opposing, I think, in the stronger amount that I'm hearing from my neighbors anyway. Then that would be defined as a business of one kind or another, opposed to like 2 weeks out of the year, you know, protecting the historical.
No, I would say that you've put your finger on a critical distinction, something that happens twice a year. It's like you know, the Indianapolis 500 or the Daytona bike
Kentucky Derby, all of them.
convention, you know, the High Point Furniture Market, which in fact are among those national events for which you have this, and why we have that exemption from taxation. But I would think that there would be a distinction that could be made that would be defensible. A daily use of something versus something that happens once a year for an event that is pre-scheduled.
If you were calling that a business, Tom, would that not also include long-term rentals? Because that would also be a business.
So that's, as I did mention that earlier, I mean, that's, if you own a house in a neighborhood and you want to rent that out, it is a business. And you'd have to find, and that was when I mentioned the 14th Amendment, you have to find a basis for distinguishing long-term from short-term.
Is there a definition for long-term versus short-term?
There could be, I don't know what it is. But I don't, you'd have, I mean,
Transient versus,
yeah.
So is the 160D-1207 as being the most current, is it going to stay current for any length of time?
I don't know. I had a conversation just last week with one of the it was a four-person drafting committee. We're already watching in this session, we're watching a spate of bills come through that would undo all of the very careful, transparent, open discussion that we did for 160D is now being changed by a legislator taking care of his or her buddy who wants to come in by ambush and drop a bill in and see if they can get political support without any careful consideration as to whether it's good law. So we knew that at the time that it was going to happen, but I am proud to say that we were able to keep it from becoming 160D, from becoming a Christmas tree type of bill where everybody saw it was moving through and wanted to hang their favorite legislation on it.
Yeah.
We finally had to agree to allow it to have two sections. One of them was the home builders bill, because they finally saw that we had momentum for things that they didn't. And they are section 1 of that law, and 160D is section 2. And the compromise was keeping them separate. But it's starting. No reason why you can't be one of the people or among a group of municipalities changing that.
Well, I was going to say, that's what it seems like right now, the town, really, there's nothing we can do to regulate the existing Airbnbs that are out there, or to even try to limit the number of in the future, homes in our existing areas.
Here's my prediction,
way.
Martha. This is very common. You have one case like the Schroeder case that comes in, and within a few months, we don't know this case is in the system because it's in a distant county and it may be local attorneys who aren't part of the statewide land use bar, so we don't know what's happening, and all of a sudden, I wake up on the first Tuesday of the month, and I get my Court of Appeals opinions, and there's a brand-new case that clarifies or limits or expands the Schroeder case. So now we have new meanings, we have some new norms, and it opens doors or windows to do something.
If an HOA has the power to restrict these, that gives an HOA more power than the city, it seems
right.
to me.
Well, all
That's
those
right.
HOA bylaws are more restrictive than the town's
Yeah.
ordinances. Yeah.
Yep.
That would
Sorry,
fall
it was
under
a pest
contract
control
law,
hit.
correct? That would fall under contract law because you sign a contract.
Yes,
to purchase
that's
that
exactly
house
right,
with
when you
that
purchased it.
HOA in place.
Yeah.
But even at that, the town wouldn't regulate that. That would be something the homeowners association would have
That's
to
right.
go after, sue, and work at it from that aspect.
Yes.
Is there anything that we can research? You said this hotel ordinance. Peg mentioned a few things that our attorney could look at.
Actually, it's not much. The School of Government has some articles on it. You've already heard me say that I think one of them is more of aspirational and hopeful as to what you might do, but I feel strongly that if I were litigating on the other side, I could shoot it down. I hate to put it that way, but that is how I interpret that.
That's a real response.
Okay.
Thank you.
Does anyone have any further questions for Tom this time?
Thank you for coming out.
Thank you,
Very
as
much.
always,
Very
for
much.
enabling me to be here.
Thank you very much.
Thank you, Tom.
Very informative. Seeing no further questions for Mr. Terrell, do I have a motion to adjourn the town council meeting?
Motion to adjourn the town council meeting.
All in favor?
Aye.
All opposed? Madam Chairman?
Okay, can we have a motion to adjourn the planning board meeting?
So move.
Thank you. All those in favor say aye. Aye. Any opposed? All right, we are also adjourned.